Haji Joni Emirzon M.Hum.
Our speaker, Dr. Ilyana binti Sherosli, Faculty of Law and International Relations, Universitas Abdini.
And then, our respected Vice Dean 3 of Research, Community Service, Innovation, Commercialization, Cooperation, International Affairs, and Alumni, Dr. Meria Utama, LL.M.
Wildan, sit. Jangan.
We'd like to remind all of the participants to be seated on the seat that already exists in here and be standing for our seminar that will be start just in a minute.
Assalamualaikum warahmatullahi wabarakatuh. Shalom,
Om Swastiastu,
Nama Budaya,
and greetings to all of us.
the Honorable Dean of Faculty of Law, Sriwijaya University, Professor Dr. Joni Emirzon, M.Hum.
The respected Vice Dean 1 for Academic Affairs, Student Affairs, and Quality Assurance, Dr. Muhammad Syaifuddin, M.Hum.
The respected Vice Dean 2 for Planning, Finance, Resources, Procurement, and Logistics, Professor Dr. Iza Rumesten, R.S. M.Hum.
The respected Vice Dean 3 for Research, Community Service, Innovation, Commercialization, Cooperation, International Affairs, and Alumni, Dr. Meria Utama, LL.M.
The respected Heads of Study Programs of Master of Law, Master of Notarian, and Doctor of Law.
The respected heads of departments Criminal Law, Civil Law, Constitutional Law, Administrative Law, and International Law.
The respected the speakers of today's event, Dr. Ilyana binti Sherosli from Faculty of Law and International Relations, University Sultan Zainal Abidin, Malaysia.
Dr. Prosper Simbarashe Magushu from Vrije Universiteit Amsterdam, Netherlands.
Dr. Meria Utama, LL.M, Faculty of Law, Sriwijaya University, Indonesia.
Dr. Salia Galasintu from Department of Law, Faculty of Social Science, Kasetsart University, Thailand.
The respected invited guests from Taman Siswa University,
University of Palembang,
UIN Raden Fatah,
Muhammadiyah University of Palembang,
Syahya Kirti University,
Sekolah Tinggi Ilmu Hukum Sumpah Pemuda,
PGRI University of Palembang,
Kader Bangsa University,
IBA University,
and Prasetya Mandiri Polytechnic.
as well all lecturers, staff, and students of Faculty of Law, Sriwijaya University, whom we are proud of.
We offer praise and gratitude to Allah Subhanahu wa Ta'ala, for by His grace we are able to hold this international seminar with the theme Smart Contracts, Blockchain, and Arbitration, the Evolution of International Dispute Resolution.
Allow us to introduce ourselves. My name is Falik Endria Zubahda, and my partner,
Karenina Fernandia.
we will be serving as your masters of ceremony, guiding the courses of today's event.
Now, before we begin this program, let us open together by reciting the Basmalah. Bismillahirrahmanirrahim.
Our first agenda is singing the Indonesian national anthem, Indonesia Raya, and the Sriwijaya University hymn, led by Amarayadori Irawan.
All attendees are kindly requested to rise.
Sriwijaya, lambang kemajuan bangsaku, dengan falsafah Pancasila, mengabdi kepada Ibu Pertiwi. Ilmu alat pengabdian untuk menerangi alam semesta dengan semboyan pengabdian ke arah kejayaan abadi. Universitas Sriwijaya, sumber ilmu sepanjang masa, membentuk generasi baru yang penuh semangat untuk mengabdi, melatih bunga yang suci, lambang agung keluhuran cipta, dengan rahmat Tuhan yang esa, menuju masyarakat adil makmur.
All attendees are kindly requested to be seated. Next agenda is welcoming speech and opening of today's event by the Dean of the Faculty of Law, Sriwijaya University, Profesor Dr. Joni Emirzon, M.Hum, to Professor Dr. Joni. The floor is all yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning. Please be open eyes all. At the first time I want to say welcome to Dr. Liliana again in Palembang. Okay, first of all, let us offer our gratitude to God Almighty for His grace and blessing that allow us to gather here today, both in person and virtually, for this prestigious international seminar on smart contract, blockchain, and arbitration, the evolution of international dispute resolution, cooperation between the Master of Law and the International Law Department, Faculty of Law, Sriwijaya University. Ladies and gentlemen, allow me to extend my warm greeting to our all speakers today. The first, Dr. Liana binti C. Surusli, Faculty of Law and International Relations, University Sultan Zainal Abidin, Malaysia. Welcome to Palembang again. And then second, Dr. Prosper Simbarase Mangucu, Prince University Amsterdam, Netherlands. Welcome to Palembang by Zoom. Hello. The third, Dr. Meria Utama, S.L.M, Fakultas of Law, Universitas Sriwijaya. Saya itu. The next, Surya Galasintu, PhD, Department of Law, Faculty of Social Science, Kasat University, Thailand. Welcome to in Palembang. And then the respective lecturer and academic and staff. I think this will be Dean of Faculty of Law in Palembang. ada Universitas Palembang, Sakya Kirti, Taman Siswa, Kader Bangsa, and others. Yeah. And then the next, the organizing committee, who has worked tirelessly to make this event a success. Thank you for committee. Yeah. And then of course all the participants joining us today, but physically and online. I think many lecturer and my student, yeah, in other faculty of law in Palembang. Ladies and gentlemen, it is a great privilege for me to extend a warm welcome to all at this international seminar hosted by International Law and Master of Law Department. Throughout the year, our faculty has remained dedicated to experiencing excellent to legal education and research at both the national and international level. The seminar serves as clear evidence of that commitment, as it brings together leading experts in the field of law to discuss various contemporary legal issues and challenges, particularly those related to the development of digital technology, the use of smart contract and blockchain, as well as arbitration mechanism in international dispute resolution. And then the theme of today's seminar is trend topic, I think, yeah, the smart contract, blockchain, and arbitration, the evolution of international dispute resolution, highlight the various development and challenges international dispute resolution in the era of digital transformation. Technological advancements such as smart contract and blockchain have brought significant change of cross-border transaction and legal relationship. This situation requires international arbitration system to continuously adapt to the rapid pace of technological progress. Ladies and gentlemen, the use of smart contract enable agreement to be executed optimally and more efficiently, while blockchain technology offer a transparent, secure, and decentralized system for recording transaction. On the other hand, this development also create new legal challenges, including the validity of digital contract, data protection, cybersecurity, cross-border jurisdiction, and the enforcement of arbitral award in dispute involving digital technology. And then, therefore, this seminar is expected to serve as a platform for the exchange of ideas and economic perspective in order to encourage the development of more adaptive, modern, and effective international dispute resolution system in digital era. And then again, I would like to express my sincere gratitude to everyone for your participation and presence. I hope that today's discussion will deepen our understanding and strengthen cooperation among our institutions, thereby contributing to the expenses of legal education and practice today toward a more just and better society. With great pride and optimism, I hereby officially declare this seminar open under the term Smart Contract, Blockchain and Arbitration, the Evolution of International Dispute Resolution. I hope this event will provide invaluable insight, benefit, and inspiration for all of us. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Dean, for the amazing speech. Next, to bless and ensure the smooth runnings of today's event, let us recite a prayer led by Muhammad Mediano Al-Fajri.
Assalamualaikum warahmatullahi wabarakatuh. Allow me to recite a prayer in accordance with Islamic tradition. For those of other faiths, Please feel free to pray in your hearts according to your belief. A'udzubillahi minasyaitonirrajim. Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin. Wassalatu wassalamu ala asrofil anbiya'i wal mursalin wa al sayyidina wa maulana Muhammadin wa ala alihi wa sahbihi ajma'in. Ya Allah, Ya Rahman, Ya Rahim, we offer our deepest gratitude to you for your blessing and grace. It is through your kindness that we are gathered here today for international seminar with the theme Smart Contract, Blockchain, and Arbitration, the Evolution of International Dispute Resolution, an event that we hope will provide us with new insight and knowledge. Ya Allah, Ya Rahman, Ya Rahim, do not burden us beyond our capacity. Protect us from all mistake and misfortunes. Grant us the strength to face every challenge that lies ahead. Ya Allah, Ya Muhaimin, we seek refuge in you from despair and failure. Inspire us with the spirit of continued learning and growing. May this event serve as means for us to deepen our knowledge and skills in the field of law. Ya Allah, the most compassionate, the most merciful, grant health, blessing to all participants of this event. May the knowledge we gain today become of a lasting charity, benefiting both ourselves and others. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina azabannar. Subhana rabbika rabbil izzati amma yasifun. Wassalamun ala mursalin walhamdulillahirabbil alamin. Wassalamualaikum warahmatullahi wabarakatuh.
Amin, amin, ya robbal alamin.
May our prayers be answered by Allah Subhanahu wa Ta'ala. Next agenda is giving certificates and souvenirs to the speakers and moderator that will be presented by the Dean of Faculty of Law, Sriwijaya University, Professor Dr. Joni, Emirzon, S.H. M.Hum. To the first speaker, Dr. Ilyana Jerosli.
From Faculty of Law and International Relations, University Sultan Zainal Abidin.
Geser apa diem deh. Habiskan coba diem. Meja kan. Iya.
Next to the third speaker, Dr. Meria Utama, S.H. LL.M, Faculty of Law, Sriwijaya University.
And to the moderator of today's event, Mr. Wildan Askal Fikri, SHMH.
The next agenda is group photo session. The Dean, Vice Dean, speakers and lecturers may welcome to take the place.
Posisi bahunya A.Md. Bahunya atau isi bahunya masuk bahunya. Awas ngangkut kamera. Sudah siap semuanya? Oke. Kamera. Oke. 1, 2, 3. 1, 2, 3. Semuanya unggul, Bapak Ibu. Oke. 1, 2, 3. 1, 2, 3. Oke. Gaya bebas, Bapak Ibu. Oke. Ambilin beda. Aku butuh dari aku. Di sini 1, 2, 3. 1, 2, 3. Oke, terima kasih. Kaki. Turun dulu. Sekutu.
Next speaker, certification to Dr. Prosper Simbarasi Magucu from Meria University, Amsterdam, will be presented via Zoom.
And then for our fourth speaker, Dr. Salia Galasintu from the Department of Law, Faculty of Social Sciences, Kampus University. Thank you very much. We hope the small gesture reflects the warmth of our hospitality and the sincerity of our gratitude to each and every one of our distinguished speakers for making the journey to be here with us today.
And the next agenda is the moment that we all been waiting for. Is the presentation of seminar materials that will be led by our moderator, Mr. Wildan Askal Fikri SH M.Hum.
But before we start the main session, let us read the CV of our moderator first. Mr. Wildan Askal Fikri SH M.H. is one of the lecturers on Faculty of Law on Sriwijaya University. He finished his bachelor degree on Diponegoro University and his Master of Law degree on Gajah Mada University. He is active on a lot of academic research on the topics of international law, which is relevant to today's team. So, because of that, for Mr. Wildan, the floor is all yours.
Thank you, Master of Ceremony. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. My name is Wildan Askal Fikri. I'm lecturer of International Law, Faculty of Law Unsri, and I will serve as the moderator for today's seminar entitled Smart Contract, Blockchain, and Arbitration: The Evolution of International Dispute Settlement. Ladies and gentlemen, the development of blockchain technology and smart contract has fundamentally transformed the landscape of international commerce and legal interaction. Transactions today are increasingly decentralized, automated, and borderless, challenging many conventional principles of international law. These developments not only create new opportunities but also generate serious legal challenges concerning jurisdiction, enforceability, and legal certainty in international dispute settlement. Today's seminar is both timely and important for academics, practitioners, and students interested in the evolving relationship between law and technology. Therefore, this morning, allow me to warmly welcome four outstanding speakers who are joining us today. The first one is Dr. Ilyana Binti Cherosli from Fakulti Undang-Undang dan Hubungan Antarbangsa Universitas Sultan Zainal Abidin. The second one is Dr. Prosper Simbara Simagucu from Vrije University Amsterdam. And the third one is Dr. Meria Utama from Faculty of Law Universitas Sriwijaya. And the last one is Dr. Sarya Galasintu from Kasetsart University, Thailand. Let us warmly welcome and appreciate their presence in today's seminar with applause. Before we begin, please allow me to briefly convey several guidelines. The first one, each speaker will have approximately 15 to 20 minutes for the presentation. The next one, a discussion and Q&A session will follow after all presentation conclude. And the last one, participants are kindly requested to maintain order and mutual respect throughout the seminar. Thank you for your cooperation. Ladies and gentlemen, it is now my pleasure to introduce the first speaker. Yeah, the first speaker. She is Dr. Ilyana Binti Cherosli. Dr. Ilyana Binti Cherosli is senior lecturer at Fakulti Undang-Undang dan Hubungan Antarbangsa Universitas Sultan Zainal Abidin. She complete her bachelor and master at University Islam Antarbangsa, master at Sussex University, and doctoral degree at Sussex University. She concerned in international law, also international contract and international dispute settlement. Well, without further ado, it is my pleasure to invite our speaker, Dr. Ilyana Cherosli, to deliver her presentation. Dr. Ilyana, the floor is yours.
Assalamualaikum. All right. Assalamualaikum and a very good morning. Thank you so much to Mr. Chairperson, Mr. Wildan Askal Fitri from Faculty of Law Unsri. Okay, and thank you so much to Professor Dr. Joni Emirzon, the Dean of Faculty of Law, and also Dr. Meria Utama, was Dean for Research, Community Service, Innovation, Commercialization, Collaboration, Internationalization, and Alumni Affairs. So many jobs that she has to, do. Thank you so much for inviting me again. Thank you so much, Unsri, Faculty of Law, for having me again. Also, Dr. Irsan, the coordinator for Magister Program. Mr. Adrian Nugraha, Dr. Adrian Nugraha, the head of International Law Division. Also, thank you to the three speakers as well. I would like to say hello to the other two. Hi, I'm Dr. Ilyana from Malaysia. Dr. Prosper Simbarashe Maguchu, sorry if I pronounce your name wrong, from Universitas Amsterdam. And Dr. Saria Gala Sintu from Faculty of Social Science, Kasar Sat University, Thailand. Hi and hello. All right. So for the topic for today, maybe we can share our slides. Yeah. Ada presentationnya tadi? Okay, terima kasih banyak. Okay, alright. So for the topic of today is pertaining to smart contracts, blockchain and arbitration in Malaysia, legal readiness and challenges in the digital era. So when I received the invitation from Dr. Meria and Ms. Rizka, and look at the topic, I was like, oh, this is a very important topic that Malaysia still have yet to do something about it. So this is a very good one. So I hope I can learn many things from our other counterparts in Indonesia, Netherlands and also Thailand. So why does this matter actually? So I'm going to see from the perspective from the position in Malaysia, Malaysian law, yeah? So maybe we can go next. Why? This is very important topic because the rise of digitalization, now we have cryptocurrencies. Still, we are still not yet know whether this is actually legal or not. Can this be a legal tender or not? Yeah, tokenized assets, smart contracts, we have decentralized finance and blockchain marketplace. So the legal system that we currently have, the law that we have, international law and domestic law, will build around parties that we can identify. The parties can be you and me, someone, something, a person, or a company that we can identify. So we built our law upon territorial jurisdiction. So the law in Malaysia is different than Indonesia, of course. We have written agreements. For example, in New York Convention, the agreement should and must be in writing, yeah? And central institutions. However, digitalization challenged everything, isn't it? Now geographical, territorial is no longer a thing. So how so the central question is this: can existing law in Malaysia and maybe in other country regulate those decentralized transactions? Next, please. So our topic today built upon three main items: blockchain, smart contracts, and arbitration. So allow me to maybe introduce what is blockchain maybe to our students, yeah? So blockchain is decentralized immutable ledger technology underpinning digital transactions. So we are going to go into the introduction of the definition later on. Smart contracts is self-executing code that automate legal obligations without intermediaries. So for example, when you are buying something online, so you are doing something without having someone as intermediaries, yeah? And smart contracts can even have a code or computer that do or press yes for you, not you actually, clicking on yes. And arbitration is dispute resolution mechanism alternative to litigation, okay, that may be suitable to be adapted for these decentralized digital environments. So next. So in building up this discussion today, I have these research questions that I also propose to Dr. Meria. Perhaps we can maybe change this into a publication or research later. So number one, can smart contracts satisfy or fulfills requirements for Malaysian contractual law? Second, does our law, Malaysian law, recognize blockchain transactions? Number three, then how can we use dispute resolution to resolve these blockchain disputes? Can ADR or arbitration suitable? And finally, like I mentioned, we don't really have a law on this yet. So does Malaysia require legal reform in order to facilitate this issue? Okay, next. So So the agenda for today, I will first cover what is blockchain, what is smart contract, and what is arbitration. Then only we go and see suitability of whether we can resolve dispute of blockchain and smart contract using arbitration and ADR. And finally, maybe we can discuss together whether it is possible to to create some sort of decentralized or smart dispute resolution that can cater this digital issue. Okay, next. The first part, blockchain. What is blockchain? So blockchain is decentralized ledger where records are stored across distributed nodes. So Basil et al. Describe it as decentralized and secure digital ledger technology that facilitates transparent, immutable and efficient data management. So there are several key characteristics there: decentralization, immutability, cytographic authority, transparency and automation. So those are the characteristics of blockchain. So when I mentioned about the legal concern that we have, the traditional law that we rely on actually against those items. Yeah. Next one. So what currently Malaysia has to cater blockchain? So we have national blockchain roadmap since 2021 to 2025, but still not yet actually completely secured and covered. Yeah. So our B&M Bank Negara Malaysia, okay, our central bank and the Security Commission are actively involved in creating regulations, not law, but still a law, but not acts, but regulations to regulate those digital asset guidelines, whether we can buy something using blockchain, whether blockchain can be used to get something for loan, for example, can it be a legal tender? Yeah. And blockchain is being explored to enhance Sharia compliance. Is it Sharia compliance? And also pertaining to energy and estate sectors. Next. So next, what is smart contracts? So smart contract is digital protocol or code deployed on a blockchain. So blockchain, smart contract is under the blockchain, yeah, to facilitate, to verify or enforce the terms of the legal agreement. So it automates contractual conditions, i.e. the payments, obligations and enforcement without intermediaries. This is what DFLIPI gave as definition in 2021. So here, the key features for smart contracts would be automation. So it is executed automatically. Number 2, immutability. Okay, once deployed, smart contract cannot be reversed. You cannot cancel it. Third, blockchain integration. So it relies on blockchain for the record keeping. So in Malaysia, currently we don't have a specific law on this. So we are still using our traditional Contracts Act 1950 to regulate this. Actually, our Contracts Act is currently undergoing some revision, but not yet been approved by our Parliament lah. Okay, so it is still undergoing revision, which I believe to cater those items, yeah, and should be take effect from next year, inshallah. But we also have, I'm not sure about Indonesia, but we have Electronic Commerce Act 2006. This is we have it to facilitate e-commerce like Shopee, any online transactions that require things, okay, contracts that don't have to be present in order to buy it. Yeah. We also have Digital Signature Act that allows digital signature to be tendered and to be enforceable in contracts. Next. So this would be our Malaysian contract law framework. I know this is quite different, perhaps. I believe I am the only common law representative here, because Thailand, Netherlands and Indonesia, 3 of the countries are civil law countries. So it's good to see the comparison. So I believe when I spoke to my friend Dosan from Indonesia, they are calling it the law of obligation, ya. Betul, benar tak? Obligation law, ya, kontrak, ya. Tapi kita tidak ada law of obligation. Kita panggilnya contract law. Yeah. So Malaysian contract law framework, okay, which is similar to the UK system, okay. So we have certain items that we need to satisfy. For example, of section 2A is pertaining to offer. There must be an offer from A to B. Yeah. Section 2B, acceptance. Another person must accept. And then we have section 2D on consideration. There must be something. For example, I'm buying this computer from Dr. Meria. She gave me her computer, I gave her money. That's consideration, price, the payment. And maybe Dr. Meria can mention from Indonesia later whether it's the same or not. And then Section 10 is pertaining to free consent. Both parties must have consented to the transactions. If not, it can be revoked, it can be cancelled because of that. Those are the elements we have offer acceptance, consideration, intention to create legal relation, consent, yeah. And finally, we have it must be lawful, competent, not be a minor, must be a sound mind. Those are the items that a contract should have to possess, should fulfill before it can be a legit, a valid contract. So in Malaysia, agreement is not contracts. Not all agreements are contracts, because if those elements are satisfied, then only it become a contract. If not, it becomes an agreement only, gitu. Ya, lainnya mungkin, alright. Jadi persoalannya di sini, whether in smart contracts, okay, online using automation, how can we satisfy those elements? We don't have a law to regulate on that yet. Yeah. In fact, we have several other sections, okay, pertaining consent. Jadi di Malaysia itu consent amat penting, very important, okay, that both parties must possess free consent, must not be any element of fraud, any element of misrepresentation, any element of mistake, okay. Therefore, for smart contract that execute automatically, what if there is coding error? What if there is changed circumstances? Okay, that kalau contohnya section 20 and 21 pertaining to mistake, yeah. Mistake is when, for example, I want to buy a house from Dr. Meria, so a house number 30. But when I see the house, I thought the house number 31 is that house. Dr. Meria also thought the same. So when both of us mistaken to that specific identity or existence of the item, so we both commit a mistake here. So the contract can be cancelled, yeah. But in automation, in smart contract, those things happen frequently. So how can the contract be easily cancelled just like that? So how can transaction hari-harinya gimana gitu kan? Next. Okay, itu pertaining to our traditional, our Basis Contracts Act. Next, we have Electronic Commerce Act 2006 and Digital Signature Act. This is when kita baru mula-mula ada komputer lah. We just have the computer, we just have internet, yeah. So those are the sections, the acts, the legislation, statutes to recognize. Okay, if kita sign online, okay, digital, it will be recognized. It will be a valid contract. Yeah, you don't have to be present. Yeah. And also legal recognition for electronic messages. If you send something by email, contract by email, it is in writing. It is considered in writing, for example. Yeah, but we do still. I believe the E-commerce Act is still undergoing some sort of revision as well. Yeah, to accommodate automation and coding. But up until now, we still don't have. Yeah. Next. This is our evidence. Evidence itu pembuktiannya kalau di sini, ya. So Evidence Act, we have section 19A, 90B and 90C to include electronic evidence. For example, computer generated documents, presumption regarding computer documents and weight of the electronic evidence. Previously we do not accept that, but recently we accept it. Right? Next. So this is the problem here, smart contract and jurisdiction, which is I think very related to mine and Dr. Meria's research interest, ya, international trade, ya. So jurisdictionnya, contohnya, ya, buyernya di Malaysia, alright, from Malaysia, developer in Singapore, platform in USA, alright. So maybe developer from Singapore, but the contract, the business di Indonesia, contohnya, ya. So where concluded actually the contract is? Which court, which law that we have to follow? It is online, right? It is digital. So the traditional connecting factors, so perhaps Dr. Meria and I will always teach about conflict of law, ya. Kita tengok connecting factors, place of contracting, domicile, where is the seat, where is the best place, best venue to decide on this matter. But when it comes to smart contracts, then in Malaysia we didn't have any clear framework as well. I'm not sure about other country. Perhaps I'm very happy to listen after this. What do other country have? Okay, next. This is pertaining to regulatory access. So our central bank, okay, create this Anti-Money Laundering Act, AMLA, yeah. Also Capital Market and Services Act. But this is to pertaining to trading online, digital asset, whether it is possible or not. But smart contract goes beyond that, right? So not just on that. This is just to regulate pertaining to monetary values. Next. This is Security Commission of Malaysia. We have many rules, okay, pertaining to investor protection, okay, to avoid fraud, to ensure that the market integrity in Malaysia is still protected, yeah. But this is pertaining to still trade exchanges. Next. So I remember last year, a student of mine from undergraduate, okay, the pair of them are doing this position on the legal tender status. So whether blockchain or smart contracts can be classified as legal tender or not, yeah. So basically we still don't have a proper law case and not even a law to protect this, okay. But Bank Negara Malaysia only have regulations pertaining to money laundering, but we don't have yet anything on this. Next. Therefore, for smart contracts in Malaysia have many beautiful and non-beautiful risks, yeah. We have coding defects, we have failures, cyber attacks and vulnerabilities. Of course, we have cybersecurity acts, but when we mention about smart contracts, it involves individual to an individual, kan? So we still don't yet have. Next. So something for all of us to think, the gap. So who should be responsible when a code fails in blockchain and smart contracts? Is it the programmer? Someone that wrote the code. The programmer can be from anyone, any country, kan? Kalau IT person, they can work from anywhere in the world. Or is it the developers, someone that deployed the contract? Or the owner of the platform, that holds the blockchain? Or maybe you, or us, that the user that initiate the transaction. So who should be responsible? The owner is also unclear, and who should be responsible is also unclear. So here would be the main gaps that I can identify. First is, I mentioned again, contract formation, identity, evidence, and also liability. Next. Then only, how many minutes I have? Can I still have some more minutes? Yeah, Chairman, yeah. Baru separuh, maaf ya. Next, okay. Okay, so kita udah cover what is smart contracts and what is the blockchain, what is the gap in Malaysian legislation. So, intipatinya atau kesimpulan di sini, alright. Then we want to move. Is arbitration the answer? Because litigation perhaps it's impossible to it's quite impossible for now. Esoknya tak tahu, hari ini impossible kan? To solve the problem. Why arbitration? Because arbitration, we know it's famous for the flexibility, party autonomy, the enforceability that goes beyond borders, kan? Neutral forum, okay? But there is still remaining challenge also for arbitration, which I will cover after this. Next. So why ADR matters in blockchain disputes? Because of the characteristic of the decentralized just now. Actually, it relates mostly to ADR than litigation, than classic litigation, yeah. Anonymous party, we don't know who is the party, the cross-border transaction, decentralized architecture with no single authority, rapid, automated, okay, direct execution, and the limitation of the traditional litigation pertaining to territorial tadi, proceedingnya, kan. France, certain US states and ancestral, okay, actually are actively developing framework. So if you guys are interested in international trade, you can go to the page of UN ancestral for international trade. They are having discussion right now, and I think they are holding a convention on this in order to solve this issue. Okay, next. So whether arbitration is suitable to resolve the current problem that we have, the smart contract problem, perhaps yes, because confidentiality of the arbitration. So it remains protected from the public, because when you are doing smart contracts, it's not public, right? Second, party autonomy, you can choose who would be your arbitrator. Maybe someone that is familiar or pandai codingnya kan, expertnya, technical expertise. And finally, because of the enforceability of the awards. So because of the New York Convention, compared to litigation, the awards can be enforced almost 2/3 of the country of the world. Kalau litigation itu, we must go to the specific court to obtain leave. But for award, you don't have to do that. So in Malaysia, we have Arbitration Act 2005, okay, but this does not cover smart contracts at all. This is just a traditional one, okay, that we have writing requirements. We have maybe can go next, yeah. We have mandatory stay. So if, for example, in that contract, even though smart contract mentioned that all dispute pertaining to the issue will be resolved by way of arbitration, then the Malaysian court will not resolve the issue. So if one of the party tak nak lah pergi ke arbitration, dia pergi ke court juga. The court will say no. They will guna Section 10 of the Arbitration Act, okay, you must go back to arbitration and resolve by way of arbitration. And Section 38 and 39 is exactly the same as New York Convention, where Malaysia enforce New York Convention awards directly. Next. So Section 9, can court constitute an arbitration agreement? So New York Convention and Section 9, which is the same, and also ancestral model law, requires agreement to be in writing. But what about the automated code? Is it can we say it is in writing even though we see it, but lama-lama dia hilang kan? Tak tahu di mana dah perginya. Is it arbitration agreement? Can arbitration clause be embedded into those code? Ya, kan tak nampak kan? Okay. Next. Okay, this is pertaining to Section 10 just now, stay of proceedings. Can the court pause, reverse or grant interim relief for smart contracts? Next. This would be the interim measures and smart contract dispute that maybe they can have, okay? They can order interim measures. So the interim measures is then left to the arbitrators to decide. Maybe that's the way, maybe, still a maybe. Next. Here would be enforcement challenges. I found an article when I was researching for this seminar, okay, that was just published last year in Scopus, okay. So they discuss about enforcement challenges about the New York Convention. Even though arbitration can be enforced anywhere in the world, but pertaining to smart contract, what if we cannot identify the parties? Kan, tak ada partinya, tak tahu siapa. We cannot also determine the seat of arbitration. Okay, and to locate those assets that is decentralized. And sometimes, what about the public policy ground? Is automated coding ini boleh dibatalkan disebabkan against public policy? Okay, next. Here would be the cases that have been decided not in Malaysia but other country. Yeah, for example, in Spain, a Spanish arbitral tribunal recognized blockchain records as valid evidence. Dia terima. Di China juga, case of Hanzhou Huataime, the Supreme Court confirmed that each transaction hash code is unique. So it is acceptable as architecture of the ledger. In the UK, the case of tulip trading, the High Court recognized blockchain ledger record every transaction and the location, okay, while noting that even though the identity remain undisclosed, tak jumpa siapa ya kan, but it is a key tension for enforcement purpose, but it is recognizable. In New Zealand, the High Court recognized Cryptoria's internal structured query language database to identify that cryptocurrency is significant to be owned, boleh own cryptocurrency. Next. Ini membawa kita kepada alternative to ADR, we also have ODR, online dispute resolution. So under online dispute resolution, we have online negotiation, which is simpler, online mediation and online arbitration. Perhaps jika arbitration bukan tidak boleh diguna, we can use online negotiation and online mediation first to try and check whether it is able to resolve the smart contract issue. Next, this is a very 2 minutes ya. Yeah. This is a nice, very important and nice new thing that I found online. Yeah, Kleros, Aragon and beyond. Okay, ini namanya Kleros, Aragon Court and Juice Protocol. Okay, this is blockchain dispute resolution that already have. Udah ada, ya. Yeah? The system use code, okay, directly to the smart contract, and then if the parties have issue, they can resolve by way of ODR using this Kleros, Aragon and Juice Protocol. Next, but still, ini akhirnya ya, maaf ya. Okay, still, okay, using this Aragon, Kleros and Juice Protocol, when they want to enforce the award, we call it award, yeah, whether it can satisfy the New York requirement of the seat of arbitration, the writing requirement, and the identification of arbitrator, because using automated, jurinya, arbitratornya itu juga dipilih online kan, ya, yeah? And also the recognition of award. So does automated, okay, you click, dia yang pilih, terus keluar keputusannya kan, awardnya. Boleh enggak kita recognize award ini? Itu persoalan dia lah. Alright, next. Itu bawa kepada public policy. It is easier for the other party to go to the court and cancel this award, saying that this is against our public policy. Who are this court? Who are this person that cannot be identified? Next. Okay, kesimpulannya udah habis. Ya. Yeah. Kesimpulannya, next. Okay. Towards smart contract resolution, dispute resolution, ya. Yeah. Bagaimana kita harus cari resolutionnya untuk selesaikan masalah ini? Kita tahu what is clear, arbitration might be suitable. Maybe if not arbitration, we have mediation, we have negotiation, but not enforceable directly. Second, there are many things that remain uncertain. So maybe we need some sort of international law or international model law that can help us to define certain things and to give legal position of certain things. Then only we can decide on dispute resolution. That's all from me. Thank you so much. Maaf ya, lebih waktu.
Yeah. Give applause for Dr. Ilyana. Yeah, thank you very much, Dr. Ilyana, for the insightful presentation, especially for cryptocurrency enthusiasts. Our student is a lot of cryptocurrency enthusiasts. Yeah. We now proceed to our second speaker, Dr. Saria Galasintu. Hello, Dr. Saria.
Hello, can you hear me?
Yeah. Let me briefly introduce our honorable speaker, Dr. Saria Galasintu. She complete Bachelor of Law and Master of Law from Thammasat University, Thailand, and finish her PhD at University of Reading, UK. Despite a lecturer, Dr. Saria also a lawyer and arbitrator. She also active in academic research. She has a lot of publication related on contract, arbitration, as well as comparative study of law. Without further ado, we now proceed to our second speaker, Dr. Saria Galasintu. The floor is yours. Give applause to Dr. Saria Galasintu. Any problem, Dr. Saria?
Oh, sorry, I'm trying to share my slides.
Oh.
Just 1 second, please. Okay. Okay. My apology, Mr. Moderator. May I send my PowerPoint for you to share for me? I couldn't share from here. I don't know what the technical problem is. My apology.
Oh. Dr. Saria, our committee will help to share your presentation. Maybe our committee will chat you by WA. Maybe we can help you if you have any problem.
Yes, please. I'm going to share my slide to one of your team. Very fine. Yes, I just sent my PowerPoint to one of your team, and I can start right now in order to save time. My apology for the technical problem happened earlier. Right, can you hear me still?
Yes, your voice is clear.
Okay, right. Thank you. Well, first of all, I would like to thank the University of Sriwijaya and the team for inviting me to be part of this seminar. Actually, mainly I focus on the consumer alternative dispute resolution in Thailand, but I would like to share with you regarding the topic of the blockchain, smart contract, arbitration, and the evolution of the international ADR. What the experience that Thailand have, right? So if in Thailand have the blockchain smart contract dispute resolution, not if, but in Thailand we do have the blockchain technology, we do have the smart contract, we have the ADR, alternative dispute resolution, alternative means, and also the litigation. But for blockchain technology, it's still new in Thailand, but the law is keeping up to the technology and the businesses. So next, please. Yes. So for the smart contract in Thailand, although the Bitcoin cryptocurrency in Thailand, there are some in the businesses, but the Bank of Thailand and also the security authority of Thailand does not recognize this cryptocurrency and Bitcoin yet. So that come into an issue that the law needs to follow up and keep it up with the technology, where the Bank of Thailand is comments is of the opinion that it's sensitive, and Bank of Thailand is not recognized this car yet, but keep studying and see the central bank currency, what we may have. And if there is a dispute, then the resolution, of course, the traditional way is the litigation, which there is the huge recommendation to go for alternative dispute resolution instead. And today we're going to go on focus on the arbitration. Next, please. Right. So my outline, I'm gonna touch upon the ICT market value in Thailand, and then move to the blockchain in Thailand with examples of blockchain technology for the government services, security, and the banking, and see how is a smart contract in Thailand, the law, and also the development services agency in Thailand. And then what about the dispute resolution? In Thailand, we do have, I will show you the example of the state contract, the private contract, and some statistics by the Court of Justice Authority of the Thai Arbitration Institution. So you can see what's the number of the arbitration cases in Thailand. And then the laws and regulation, which thank you for Dr. Ilyana. Sorry if I pronounce not correctly, for the introduction, which quite many parts of your lecture just now is about the same that happened in Thailand, where although we are common in civil law, but the principles are quite the same in bit by bit. I'm gonna put to the lecture later on. And the blockchain technology, although we mentioned about the arbitration, the ADR, but I couldn't help to mention about the Court of Justice, what have they done and on process in developing for the blockchain technology in Thailand, because somehow there will be some case that need the litigation and not the arbitration. So, and then I will put you the conclusion in brief so you can see all the pictures today that we have learned at the end. Next, please. So the ICT market in Thailand, with the focus for the 10 years since the COVID pandemic, started from the 18 billion. It is focused to be a 33 million. Which, next slide, please. In this figure, it will be 70% about that is the blockchain businesses, which is growing up and will be increasing in the future. So we can see that next, please. The blockchain businesses is although new, but is ongoing, and it seems to be a part of the society whether you like it or not. So the blockchain in Thailand, we have blockchain technology, of course, but the example of the government services is started from the national plan. In Thailand, since last decade, we have Thailand 4.0, in the national plan, and we have the specific digital development plan. And now the government have the digital government, the e-government, which the core at the end, I will show you also go in the same direction with the digital code and the e-code in order to support and use the blockchain technology for the benefit or maximize the technology for the benefits of the authority. Next, please. So it's 20-year digital landscape of Thailand, although I don't have the time to go in detail about this landscape, but we are moving forward in order to maximize the blockchain technology, like I mentioned earlier. Next, please. And the example is to adopt the DLT for the public services and also other authority services. Next slide, please. For example, secure healthcare records, e-government procurement, tax refund, scriptless bond. This is all with the blockchain technology. This is a positive side that Thailand has. Next, please. And for the securities, the specific law of the emergency decree on digital asset businesses in 2018 defined the digital assets to include cryptocurrency, digital token, and these facilitate the businesses and also the Security and Exchange Commission with regard to the initial coin offering. So that part is somehow they maximize with the blockchain technology, but however, the clearing and the settlement is still transfer and receive through the BASnet, the settlement bank, and the instant security settlement is still under studying process and development, and that is where the bid of the authority and the Bank of Thailand that beware of the blockchain technology for the security. Next, please. And for the banking, there is an initiative from the main 6 Thai commercial banks that bringing the blockchain technology into their services. And right now, there are more cooperation from other Thai commercial banks and even with the state enterprises and large-scale businesses that have this company, the BCI Thailand Company Limited, helping them to apply the blockchain technology to develop their services in the banking areas and even with the state enterprises. Next, please. So the 2 services that the banking provides with the blockchain technology are the letter of guarantee, the electronic one, and also electronic bank confirmation of the blockchain. Next, please. And the laws, I'm gonna give you the main law of the smart contract in Thailand. We do already have smart contract before law. That's always the case. The technology and the practice and the businesses introduce the smart contract into the society, into the country. And the main law are Civil and Commercial Code and the Electronic Transaction Act. These 2 laws are the main laws that govern the smart contract in Thailand. Talking about the declaration of intention, it will be the same as Dr. Ilyana. It mentioned the standard form of the contract of Malaysia. In Thailand, also the same. By the civil of the commercial code, the form of the contract with the 2 parties, with the offerer and the acceptance. Then the contract will be concluded, with the offers and the acceptance. That's all we know. It's the same principle there. But next slide, please. But under the Electronic Transaction Act, the definition of electronic transaction in the Act means the transaction in which an electronic means is used in whole or in part, and also have the definition of the e-signature certified that is accepted in the smart contract, constitute the contract with the e-signature. And of course, with the Electronic Transaction Act, considering with the privacy of contract, the freedom of contract by the Act, is the smart contract considered the offer online. Electronic signature, is it considered the declaration of intention? Yes, it is automatically by electronic means. Next, please. Next slide, please. Right, and the place of the smart contract is by the Civil and Commercial Code, mainly is where the parties are, but there is the clarification of differences of the place of one party to another, of the offer and the acceptor. But under the Act, the place of businesses of the originator and the addressee is the place of the smart contract. The variety, the clarification, for example, if there are more place of businesses, then it will be the closest relationship to the underlying transaction. So the clarification will be in other paragraph of the article. Next, please. Move forward, please. And the existence of the smart contract. So under the Act, is the smart contract exists and considered as the contract? Yes. With the amendment of the Act, there are more certain, more articles that put the smart contract to be considered as one of the contract, as in the standard form of the contract in civil and commercial code. I brief out down there is the form of the data message can constitute a contract legally. Electronic data is well recognized and even extended to different territories. So now it's really linked to what Dr. Ilayana said about the, where one party in one territory, one country, another party from another side of the world. So it can be conclude, the contract can be concluded, but how to enforce the contract in different territory, that's how the interpretation, that's how the law will be involved. So in where the smart contract starts, the blockchain technology will supported, originated, but if the court fails since then in Thailand, the parties might need to go to the court to settle this issue in order to cancel the contract. Next, please. Next two slide, please. So not only the main two law of the Civil and Commercial Code and the Electronic Transaction Act, but there are also other relevant law which I don't have enough time to mention in details here. For example, the Personal Data Protection Act, the Cybersecurity Act, etc. Next, please. So this is just to show you that since the smart contract getting popular, you want to have your insurance in Thailand, you just click online, you want to buy any product, you want to have the credit card. So the smart contract is near you, nearer than you think. So the services here, there are some service provider companies based mostly in Bangkok and also in Phuket, in Chiang Mai. You can see the companies are all around, not only in Bangkok, but in the provinces where all the investment are there. Next, please. And so if there is a dispute, what the resolution method we will go for and choose for? Of course, the ADR is heavily recommended in the international level and including in Thailand. But if we say arbitration, I would like to point out the state contact and the private contact in Thailand. The state contact mainly, all the standard contract where governmental authority will sign on behalf of the government, on behalf of the authority. Every contract will be reviewed by the Office of the Authority General. But normally, mainly, there has no arbitration clause. So therefore, in order to sign the contract, normally it will be black and white, and there is not a smart contract. It might have the arbitration clause in the exception case. Normally will be a contract between governmental authorities and overseas companies, big investment, mega project, for example PPP, public-private partnerships, concession agreements, but still normally in black and white and not in a smart contract. So next slide, please. I will just have one case for you, which some of them might heard of this notorious case of the Hopewell project, where we signed and we have the project to build the road and the train system in Thailand with the Hong Kong company, and the contract has the arbitration clause. And at the end, the clause went to the administrative clause and to the administrative court. Then we lost the case at first, and then the Supreme Administrative Court asked to rehearing, and then over the first decision of the arbitration case. And then Thailand now is considering the clause, the arbitration clause in the state contract very detailed and very careful on that part, because one of the cases like this happened and it can cause a damage to the country. Next, please. So for the private contract, of course, you can see and you know that it's not only locally, nationally, but it's widely internationally applied as smart contract for businesses. But by the cases, the announced and published arbitration awards that in Thailand, it's likely that there is no private contract cases that go through the arbitration yet. But this is maybe somewhere which is not announced. I'm not sure about that. But for the Arbitration Services Authority in Thailand, there are main three authorities. First of all, is Thailand Arbitration Institute under the Office of the Judiciary. It's 30 years of experience on the most cases that they would have been handled, both the court annex arbitration and out of court arbitration. And the second authority is Thailand Arbitration Center with a specific act under the Ministry of Justice about a decade, and the Thai Chamber of Commerce. The next slide. So this is the statistics from the GAI, Thailand Arbitration Institute, just for your information to see how and type of the cases that went through the arbitration cases. It's always there, but you can see the arbitration cases is lesser. Maybe that's the example of the Hopewell case that has less cases on that. Next, please. So talk about the laws and regulation. I think the international relevant laws, we are all the same, binding, because we are the member, and that will be the same for us. But for the national relevant laws, in Thailand we have the Arbitration Act since 2002, and with its amendments. We have regulation and institutions, three institutions, for example, in the previous slides, regulation, and of course, one of the most important is the code of conduct for arbitration process. Thank you. Next slide, please. So, the blockchain technology in the Court of Justice is something that I think we need to mention, where if the smart contract will need to go through the court proceedings. Court of Justice is applying use blockchain technology in supporting their services. They have a multi-E-court and D-court, and have the plan, a specific plan for digital development plan. And in the court, they accept smart contracts in the court proceeding. Of course, like I mentioned earlier, with the Electronic Transaction Act and the Foreign Commercial Code, so smart contract is acceptable and can be proceeding. But however, there is an issue of data integrity to be clarified, to be proved in the court. Next, please. So the conclusion over here is next two slides, please. Yes. So what we have learned today is about laws and technology, where law is follow-up, but have to be expanded and has to be covered faster enough with the technology that moving forward faster. That's always the case. But with the technology, when we develop the laws, especially in this case the smart contract that are with the blockchain technology, in Thailand we have law, but the enforcement and the interpretation of the smart contract in the court proceeding and even in the arbitration cases is still challenging for Thailand, because although the arbitration is always recommended, but the negative side of maybe the time consuming, which is not sure, and also the cost of the whole process that might not be safe, and so the arbitration might not be a choice for the parties. But anyway, the international dispute resolution is developing, has been developing all along, and is the positive side of the arbitration that can resolve the dispute easier and better than, of course, it is recommended than the litigation. And in Thailand, we also still need and have some room to develop further. For example, the mechanisms for any stage we need, the blockchain technology in court proceeding, instant security settlement, issue of the data integrity proof, the arbitration clause in the state contract, and also the interpretation of the law, which always be the key of the case. So in Thailand, in the conclusion, the evolution of international dispute resolution is improving and in the positive and a good way. And I hope my conclusion here might answer what the question that you might have. But if not, then we have Q&A session and all the questions are always welcome. Thank you for your attention.
Yeah, thank you very much, Dr. Saria Galasintu, for the valuable presentation. Next, let us welcome our third speaker, Dr. Meria Utama. Allow me to introduce her CV. Dr. Meria Utama was complete her Bachelor of Law at Faculty of Law Unsri and Master of Law at Erasmus University and Doctor of Law at Universitas Pajajaran. She active in abroad training and conference, one of which is ICRC training in Swiss. She also served as Vice Dean in Research, Community Services, Innovation, Downstreaming, what else? International Cooperation and Alumni. That is 50% of our faculty affairs, right, ma'am? Okay. Dr. Meria Utama, S.L.M, the floor is yours. Give applause.
Assalamualaikum warahmatullahi wabarakatuh. Thank you very much, Mr. Wildan, or we call it Mr. Idang. And then I would like to say thank you very much for all of you guys to come in this room. And then I'm very sorry, my voice is quite sexy after after maybe concert ya. So baru 2 bulan becoming the third vice dean, memang full and many activities actually. And then I would like to say also thank you very much for Dr. Iliana. Actually, this seminar is part of international division. It is a part of my duty as the third vice dean of the Faculty of Law. And then Dr. Iliana ini just like our friends. Last year she came in here and then also give us the information about the arbitration in Malaysia. And then today come again with additional smart contract and blockchain. Thank you very much, the beautiful ladies from Malaysia. And then I would like to say also thank you very much for Ms. Dr. Saria, Associate Professor Dr. Saria. I knew her from my friend Najma. Actually, we would like to find the third speakers. And then I said that Najma from International Office of Unsri, can you find me the friend from Thailand, because we never have the speakers from Thailand. We would like to know the arbitration and also contract perspective from Thailand. And then Alhamdulillah, thank you very much, Ms. Saria, just now give us the insight about the contract, blockchain, and also the arbitration in Thailand. And then for the next is Mr. Prosper. I knew him from my friend, Dr. Harry. Thank you very much for your agreement become speakers in this seminar. And then also we would like to know about what happened the arbitration in the Netherlands. Is there any improvement? Actually, I'm the alumni of the Erasmus University of the Rotterdam. I study a lot about the contract and also arbitration in the Rotterdam, but maybe there are some development about the arbitration over there. Today our motion, our topics is about smart contract and arbitration, and of course Dr. Iliana and Prof. Sari already discussing about this. And then yes, it is a very current issues. Yeah, it is very interesting topic. And then whenever we're talking about the smart contract, everybody, all of you here, maybe ever signing realized or unrealized with a smart contract. Sometimes we buy the ticket of concert, or we buy ticket for joining online seminar. So without signing, but you just click, and then directly approve, and then the ticket come to your email or your WhatsApp, means that there is a smart contract over there. So a smart contract is a self-executing program store or blockchain that automatically enforce the term of an agreement when predefined conditions are met. Kalau kita belanja di pasar, we said, I would like to buy this, and then just like what Iliana said, that Dr. Iliana said that you give the money and then you get the things. So in this smart contract, it's not necessary, just direct all about this in your device, on your hand, yeah, or your mobile phone. Long time ago, we are so scared if we would like to go to the market without our wallet. Yeah, if our wallet left behind at home, and then we are so scared and troubled maybe, but just now you just need mobile phone, everything in your hand. Yeah, just curious. Unfortunately, just last year I came to the Turkey. There is no curious, but in London there is curious. Is there any curious London or Malaysia? Chris, you just scan something and then the payment. QR code. Okay, yes, QR code. Yeah, we say Chris, curious, just like that. Yeah. QR code, yeah, you have. Okay, so it's kind of the payment, yeah, there's the improvement. Yes, it's very easy. So the vending machine, insert money, get the product, so no cashier needed. So what for our as a human? Okay, so next, how the smart contract works already delivered by Dr. Iliana and also Prof. Sari. Just write the contract and then deploy, trigger, and then the contract is executed. It is the real world use cases of using the smart contract, DeFi, and then NFT, votings in some countries using votings, and auto insurance, auto insurance means that if you like to go abroad, then directly you just apply the contract via website or some website, and then you guys directly got the insurance, ya, and then supply chains. Atau mungkin kita from Indonesia, Anda punya Kredivo, Indodana, ya, what else, ya, ya, GoPay, ya, it's kind of, I think it's a smart contract over there, ya. Okay. So the key characters is automated, yeah. Smart contract are self-executing programs on the blockchain directly, and then immutable. It's immutable. It's transparent. Everybody can access it. Everybody can access it, and then trustless. It's trustless. No need to trust to other party. Trust the code. Just trust the code. The code will give you the trustless, and then decentralized and also deterministic. Once deployed, the code it's permanent and tamper-proof. Yeah, for instance, like Ethereum Solidity is the most popular language to write them. Yeah, last year I also already give some of the company that provide smart contract. The popular one is Ethereum. So I just make a quote, the future of agreement is programmable. So the people in here is team IT in Faculty of Law, getting important and more important the roles tomorrow. So regarding the arbitration, I provided at least 5 issues regarding the smart contract and arbitration. The first is just like what Ilyana said just now, Miss Ilyana said just now, is about the jurisdiction and the seat of arbitration. So which country has the jurisdiction? Because we don't know. We conclude in here, and then the company from USA, and then directly perform in another country. So about the jurisdiction is very, very confusing. So the core problems is the smart contracts run on the decentralized blockchain with nodes setters across the dozen of the countries. So no fixed seats, conflicting national law. I said to Ms. Meria and also Dr. Ilyana, maybe we can write about this, about the conflict of law regarding the seat of the arbitration in the contract. So can the contract only online, or must be there is an institutional arbitration to guarantee about the award of the arbitration? And then the forum selection is void, yeah. The standard forum selection clause may be unenforceable when the contracting parties is pseudonymous. May I drink first? Then I provide the proposed solution. Explicit seat clauses, and then Lex cryptographia and institutional framework and hybrid contracts. Maybe must be a hybrid contract that pair the smart contract with a traditional wrap legal agreement that contains a governing law and arbitration clause. And then the second issue is about the enforceability of the arbitral award. Of course, if there is a confusing about the jurisdiction, the enforceability of the arbitral award is also the next problem, of course. Siapa yang mau mengeksekusi putusan arbitrase? Who the one who would like to execute the arbitration's award? So there are verses on-chain reality and then legal award. Blockchain transactions are irreversible by design. Once a smart contract execute, fund moves, tokens transfer, the ledger is permanent. Code is law. Yeah, in smart contract, code is law. Means that the outcome stands regardless and pioneers. And then the legal award, the arbitral tribunal may rule that a smart contract outcome was unjust. But enforcing that award requires court and the cooperation of the parties, neither of which can rewrite the blockchain. Actually, the New York Convention that have enforced award cross-border but cannot compel a blockchain to reverse a transaction, and then still questionable today. So I also propose solution about this, about the escrow, dispute buffer, and then hybrid legal wrapper, Oracle link award, and then institutional rules. So the popular one, I opened the website from GEMS. GEMS is a quite popular institution that provided a smart contract, as well as how the settlement of dispute regarding the smart contract. You can find on www.gems, and then you can find the smart contract term and conditions. And also the ICC, the popular one, just now I discussing with Dr. Ilyana, Singapore, and also ICC provided the rules to anticipate the situation currently, yeah. Next. The issue number 3 is about the technical complexity and the arbitrator expertise. I try to find from the internet how many percent that the arbitrators actually understand about the smart contract and also the blockchain expertise, and then it is luckily only 12%. 12%. Maybe in Indonesia less than 12%. Smart contract cases involving code dispute is about 68%. So this is also, of course, a challenge also for the arbitrators or the one who teach arbitration just like us to study more and then to research more, doing research more about the technical complexity. Sometimes we are strange, yeah, about the code, the bugs, just like that. I always read, and then I always learn also, what does it mean? What does it mean? I sometimes ask my friend from L.Kom, from the Faculty of Computer, and then I said that, what does it mean like this? What does it mean like this? And then it is very interesting, actually. We can avoid it. And then propose solution. There must be the arbitrators, the arbitration institution must hire specialists that understand about the blockchains. They said that tax specialist arbitrators. And then AI assist analysis, court appointed expert, and mandatory training. If he or she already becoming an arbitrator, means that she or he must open-minded and then be trained, become understand about the blockchain, about the smart contract, or anything that currently related to the new development of the technology. We live in what we call virtual world currently. Sometimes our younger even thinking that they are married with the virtual AI people. Yeah, that's what happened now. And then the third issue is about the transparency versus anonymity conflict. Now, this one, the arbitration requires identified countries, full legal names. If you come to Bani and then they will ask your identity card and then write your name and then give you such a letter, you must be fulfill it. On blockchain, it's not necessary. So, verifiable address for serving notice. There must be address to give a notice, to call you, or to ask you to be the witnesses. And then discoverable asset for award enforcement, witness identity disclosure, and public or semi-public proceeding. Blockchain provides wallet address, pseudonymous or anonymous transaction, immutable audit trail, no bill identity verification, and decentralized or no central authority. So about the proposed solution, I try to find at least 4 proposed solutions about know your customer at the contract level. Of course, still we need to know the customer. we still need to know the identity. If you come to the Kredivo, Indodana or some things, they need still your identity card. But if it is the real smart contract, they don't need it. Even you just have a fake name, it's concluded. As long as you can apply and then you know the code and then you have appointments, it's concluded. Is it okay if there is no problem? But if there is a problem, of course it's a big question mark. How to overcome the problems, yeah? And then zero knowledge proof, and then qualified anonymity, and then seal proceeding. And then the last problems is about code bugs versus legal intent. This is code bug is an error, yeah. If you open the some website and then it said that syntax error or runtime error, logic error, means that there is a code bugs error over there. What about the code bugs versus legal intents? So, of course, the fundamental tension is smart contract execute exactly what the code says and then what the parties intended. A bug, ambiguous logic, or an unforeseen market condition can cause the contract to execute in a way nobody wanted. So, I just underline that the blockchain doesn't care about the intent. That's why what you said just now. Kalau di kita ada 13-20, ada consent of the parties, kecakapan, legal personality, ada objek, kausa tertentu, and then yes, there is an object, and then kausa yang halal. In blockchain they don't care. So this is what happened. The case is about DAO controversy, the case of a new species of the corporate governance. Yeah, it is a very popular cases that the parties loses. The parties loses almost 5,000 million, if I'm not mistaken. Yeah, so formal code verification is needed, and an intent-based arbitration, and then plain language companion, and then pause mechanism. This is the proposed solution. And then how Indonesia respond about this? About the jurisdiction, enforceability, expertise, anonymity, and the code versus intent. So I divided into two sections. Issue number 1, number 2, and number 3 about Indonesia regulatory responses about the jurisdiction. Of course, our regulation of ITE, Information and Technology, also recognize the electronic contract as legally valid, providing a baseline for digital agreement on blockchain. And then KUH Perdata, Article 13 and 20, govern contracts validity. Courts extend principle to digital contracts where parties and objects are identifiable. And then the regulation of the government, number 28, 2025, it's about the law expand blockchain legal space beyond cryptocurrency and finance. So the gap is no specific rules yet, just like in Malaysia maybe, on seat of arbitration for blockchain. There is no specific regulation about that. The parties should insert a governing law clause manually, but it's not easy in the real world. And then about the enforceability, the regulation number 13, Indonesian's arbitration and settlement dispute law, the award is final and binding. Domestic enforcement via district court exequatur. Yeah, we know that if there is a award, then domestic enforcement is via domestic court exequatur. And then New York Convention also, and then Supreme Court response enforceability. But the gap is also just the same. The award can compel parties to pay compensation, but cannot technically reverse on unchained transaction. And then expertise, just like what I say just now, lack of expertise. So this is no mandatory blockchain certification for arbitrators yet. Academic program still developing curriculum. So in Faculty of Law, we would like to change the curriculum, and then about the transaction in ITE, and then from the bachelor, master, and the doctoral program already put about the development of the technology to the curriculum. So maybe it is becoming you guys who graduated from the Faculty of Laws of Sriwijaya become academic program academician that understand about the smart contract and also about the blockchain. And then for issue number 4 and number 5 about the transparency and anonymity, of course there are some regulation, OJK regulation, UITE, and then penyelenggaraan sistem and transaksi elektronik regulation, ya, also regulate about that. But no specific rule yet linking wallet address to arbitration services on the process, as well as the code bugs and legal intent. No formal mechanism to compel code audit to reverse smart contract execution. Therefore, I give 5 reform roadmap. For instance, the specific smart contract law. It's not easy, I think. It's not easy, of course, but we have to adapt it. Maybe with the governing the government regulation, not directly the law. And then Bani tax specialization, just like I said, for the institutional reform, Bani must adapt it about this. Of course, on 2024, Bani already declared that they have an online dispute resolution, but for blockchain and smart contract, it's more than online dispute resolution. And then know your customer arbitration linkage. And then after that, the code escrow standard, yeah, must be there is a code escrow standard that the agreement with the third party agent independent that keep the sources of the code. This is quite expensive, but if you would like to be safe, you have to escrow the code. Jadi harus disimpan kodenya di pihak ketiga. Mahal memang, expensive simpanan ini. And then the next is maybe Miss Meria, and then Dr. Iliana and Dr. Prosper already here. We need ASEAN or maybe the world blockchain harmonizations, the rule, yeah. So that is the end of my presentation. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Dr. Meria Utama, for the enlightening presentation. Now we move to our final speaker, Dr. Prosper. Dr. Prosper Simbarase Magucu from Vrije University Amsterdam. Allow me to present his CV. Dr. Prosper finished her Bachelor of Law from University of Zimbabwe, and then his Master of Law from University of the Western Cape and Humboldt University, and complete his Doctor Juris at University of Gießen. Dr. Prosper. Dr. Prosper, are you hear my voice, Dr. Prosper?
2. Hello, good morning. Can you hear me? Hello, good morning.
Hello, Dr. Prosper.
Good. Yes, hello, hi, good morning. Can you hear me?
Yes, yes. Well, Dr. Prosper,
Yes.
time is yours. Please, please.
All right. Good morning, everybody. Assalamu alaikum.
Waalaikumsalam warahmatullah.
Thank you. Thank you. So I'm just trying to adjust. Technology just beat me a little bit here. Is it possible for me to share my screen to show my presentation? How would you like me to go ahead?
You will share screen by your own self, or our committee will help your presentation, Doctor.
Okay, let me try to see if I can share my screen by myself so that it's easy for me to move through the slides. Okay. Let me hold on. I'm sending my presentation straight away. So apologies for this. Let me send my presentation. I think Professor Dr. Herion is in the room, right? Can I send it to him directly right now? Can you confirm that you can see my
Yes,
screen?
yes.
Okay. Now, how do I do it? Yeah, I think now that looks much better for me. All right. Thank you. And also thanks to the previous speaker, did already a fantastic job in giving a very specific, precise definition of smart contracts. So my job has already been made much easier today because most of the basics, yeah, including the introductions, has already been covered by previous speakers. But there's no harm sometimes in repeating certain key elements. And allow me just in the next, let's say, just the next 10 seconds to just go through again the main key elements of what exactly is a smart contract. This is a program created contract stored already in blockchain, automatically performs actions without the need of assistance of human beings. As the previous example that was given, just like a vending machine. So with a smart contract, for example, you can even borrow or take a loan with no intermediaries, without brokers, even without a bank in existence, which is why it is often used in finance, in trade, supply chains, and digital assets. It is really making life easier. Yeah? Like any other technology, smart chains, of course, can be a double-edged sword. In Indonesia, you have a kris. Is that a double-edged sword? So it can cut both ways. It can have its positive, and it can also have its negative implications. So I'll delve into that immediately, some of the challenges. To understand the challenges, of course, it is important that we go back to the basics. What was there before smart contracts? We had our traditional contracts depending on codes and human interpretation. Yeah, you make a contract, there is an argument, we have to try to get back to the humans and see if there was consensus added them through their actions of what is written. So, thing is that smart contracts are executed automatically through code. I don't need to repeat this, has already been mentioned previously. But the problem arises when the code does not reflect the party's intentions. So what do we do then under such circumstances? Questions also arise. about the liability, fairness, and of course, which legal remedies to pursue. And this is where blockchain systems that are operating, whether it's at a global level or national levels, come into question or has to be regularized, in terms of the law. And I'll get into that, as has already been also suggested already by the previous speaker, who already put me on a serious spotlight that I should go into the arbitration using the Dutch experience as an example. I have noted that, and I was busy already amending my slides. So that will come later before the conclusion. All right. So coming back to the elements of a valid contract, because this is important to then set the tone to discuss how in the Netherlands arbitration is dealing with smart contracts. So in most legal systems, and I believe in Indonesia, this is not a special exception, you still require an offer, an acceptance, consent, plus a lawful purpose to create a contract, right? So the same also happens in the Netherlands. And to understand the Dutch law, you of course have to situate the Netherlands in the European Union. Yeah, I believe this is common knowledge. So you understand that most European countries, Western European countries, their legal framework is governed via the Union, the EU, the European Union, which is the international organization, like ASEAN, that regulates almost every aspect of life, whether it's law, social, sports, whatever, in Europe. So EU law generally accepts a good thing. It does generally accept smart contracts if the main elements, traditional elements such as offer, acceptance, and consent exist. The challenges arise where parties are anonymous, or sometimes they use what have been called here wallet addresses. So courts do often at times struggle to determine the true intention of the parties under such circumstances where they are anonymous or they have used wallet addresses. So that's where the court may become technically precise, but legally unclear. So I mentioned in the very beginning, and other speakers before me have mentioned the advantages, especially in the ease of doing business that has been facilitated by smart contracts. However, as I mentioned, they can be a double-edged sword. They cut both ways, both positives and disadvantages, pros and cons. So codes that are used in creation of smart contracts can technically precise, very precise, even better than human beings, but legally they can be unclear, and we have to separate the two. Or even for any lawyer, whether it's in Indonesia, a lawyer practicing in Europe, you now need to be technically savvy, but also you need to know the law. Two challenges here. You have to know the law, you have to know technology. So if the faculty has to address this, there was a plea by the previous speaker that the department should probably lead in producing graduates that are technically are ready to solve some of the challenges that are being presented by smart contracts. Then you also need to make sure you partner with other departments that are fully conversant, fully aware and competent enough to deal or address technical issues. That's a very important point that I illustrate here about technicality and legally. So you have to understand these two things, technology and law. So you need to, let me move to the next slide. Speak briefly about the European approach before I then go into the Dutch approach. Yeah. So in the EU, the approach is quite clear and straightforward. Yeah. There is what is called a technology neutral approach to regulation. It's neutral. Whether there's technology or no technology that has been used, They don't take cognizance of the technological part. It's a technology neutral approach. So existing contract law, the original traditional contract law usually and by and large applies to blockchain agreements. So the EU aims to harmonize rules across the member states, and they accept that existing contract law applicable in member states should also, under general normal circumstances, also apply to blockchain agreements, smart contracts. Yeah. But at the same time, consumer protection and private data laws should also be applicable. So there's need to strike a balance. So the EU, as the point, last point clearly mentions here, seeks to strike a balance between innovation, technology, and legal certainty. These two very important, apologies for the, these two very important areas that we are focusing on today. It's about technology, it's about law. So there's the need to balance the two. And this is what the EU tries to do, or is attempting to do by taking this technology neutral approach to regulation, including regulation of smart contracts. So they have two ways they are doing so. They've employed two regimes, legal regimes or strategies. The first one is this EIDAS regulation, which governs electronic signatures and digital trust services. It supports the legal recognition of electronic agreements in the whole of the EU. So blockchain contracts may use electronic signatures for legal validity, and this is perfectly legal. The system helps create trust in digital transactions. As long as it's not fraud, as long as it is verified, then it is regarded as valid. And under the EU law, using the EIDAS regulation. Still, challenges remain. Yeah? There's now perfect system. Challenges still remain with anonymous and decentralized blockchain systems. I will address this in the last part on how the EU attempts to address the challenges. But before I do that, I will discuss a second regime, just briefly. So this is like a crash course, but I beg you, for those who are really interested in the topic, you can then use my slides to go then do a deeper research. So the second one is the MICA regulation, MICA, so which stands basically, it's an abbreviation, an acronym that stands for Markets in Crypto Assets Regulation. I was listening to some previous speakers. They also delved briefly into crypto assets regulation. The EU also does have a framework, specific framework for crypto assets regulation. So it is the EU's main framework for regulating crypto assets, this MICA approach. It applies to crypto exchanges, token issuers, and service providers. Smart contracts used in financial services, mostly in financial services, they largely, out of, for argument's sake, about 90% of them largely falls under MICA rules. So the regulation increases investor protection, but also market transparency, something that I really pride and like so much, being also with my background in anti-corruption. So there is some transparency. Nothing can be altered once the contract is, self-execution, has already been mentioned in the definition of smart contracts. Yeah. So some challenges now. Now, and the route to discuss the Dutch approach. Blockchain transactions often involve parties from different countries. Imagine somebody from Indonesia, in Palembang, doing contracts or signing a contract in an EU state, a member state like the Netherlands. It may be difficult to determine which laws applies. So courts may also struggle to enforce judgments internationally. So I'm just giving this international picture to bring this home. So blockchain immutability may conflict also with data protection rights. So these are immutable. Once executed, it's done. It's concluded, done deal. Yeah. The issues create uncertainty for international business. The challenges now. So I'm referring to this so that I can talk about dispute resolution and arbitration within that context of international business. Yeah. So some blockchain uses systems, they have decentralized arbitration. Yeah. Where what is being called blockchain justice. Yeah. These are attempts to resolve disputes through some digital platforms, no, not necessarily physical courts where one has to travel to the Netherlands to resolve a dispute, for example, if something goes wrong. So the due process, fairness remained important legal principles. So this traditional due processes, nothing changes, still applicable. Many legal systems, they also still require some judicial oversight. Even if they are digital, there's still some judicial oversight. You can still go for some form of review or even appeal through some physical or traditional judicial mechanisms. But future systems may probably combine, and this is the direction we are going. They may combine the blockchain technology with traditional courts. But this is only we're talking now of the future. And now, to answer the question that I have been begged to address, the Dutch experience. Just like the EU, of course, the Dutch law does follow the same principles. It applies traditional contract law principle to smart contracts, requiring the necessary conditions to be met: offer acceptance, consensus, mutual intention for a contract to be enforceable. And the specific law, they are just put it for the readers, the Dutch Civil Code or the Wetboek. The code establishes that contracts arise from mutual agreements, regardless of any form they take, whether they are in the form of blockchain, technology, traditionally written on a piece of paper, or whatever form, they still are regarded as a binding contract if those conditions on bullet point number 1A are met and are available and genuine. So Dutch courts take, like the EU, the international body, and technology neutral approach to contract formation. So the law does not require contracts to be in a specific format. Yeah? You can even use your foot, what they call footstool. Yeah? You can touch with your leg and the contract is regarded as binding. The same way you can also put an electronic signature, the contract is also regarded as binding. In terms of disputes, in terms of disputes, Dutch contracts present unique challenges. Rather, smart contracts, they present unique challenges for the traditional Dutch legal system, like anywhere else in the world. This is fairly an emerging field. This is a new area. And again, as I mentioned, for the arbitrators, for lawyers, for judicial officers, they need to be both technologically savvy, understanding technology, but also the law. So when disagreements arise, you cannot simply approach a court to interpret those algorithms, codes, as judges would in a written contract. It's very different, two different volumes altogether. Interpreting algorithms code and just looking at the black letter law like judges traditionally do. So arbitration now is the best, or at least the alternative best possible solution to resolving smart contracts dispute outside the conventional court systems, including in the Netherlands. If there is a challenge, and usually it's already after the damage is done, because the smart contracts are already self-executing. So damage has been done, harm has already been suffered. The next possible solution that would give much fairer justice, deliver justice to parties, is arbitration. And now, even having said that, arbitration itself is still very much grappling with these issues of smart contracts. They are now trying to embed arbitration clauses directly. In anticipating things may go wrong, you can already try to embed arbitration clauses directly into smart contracts at the time of contracting. Though questions still remain about the enforceability under Dutch arbitration law. So, answer the question again on the Dutch experience. There are still some uncertainty. There's still some legal uncertainty on some of the smart contracts. even though parties are now a bit ahead in terms of already including arbitration clauses in smart contracts, there is still some legal uncertainty in terms of the enforceability under Dutch law. The challenge lies mainly in balancing automated execution, which happens through these smart contracts, with human oversight. So how do you balance this? There's a contract that executes itself at the speed of lightning, of pushing a button. And at the same time, you also need human oversight to see if the traditional elements are still there. Is there offer acceptance, mutual understanding? So this is really complex. This is quite a complex field that the law itself is still trying to address. Yeah. So I can only reach a conclusion now, not being a really expert, and also, as I mentioned, this, like anywhere else, is still an area that is developing. Smart contracts are really transforming not only international business and finance, but also legal thinking philosophy. How do we really address these emerging issues, emerging challenges that are being posed by technology, using the traditional rules, such as the traditional laws of contracting. And the EU is now becoming a global leader in blockchain regulation, but the legal system itself is still in the process of adopting to new technologies. At the same time, you still need to adhere to human rights, fairness, legal certainty, and other things that must be protected. Yeah. So international cooperation is the only probably possible way, not an end in itself, but a means to finding an end or a solution to the future of regulation of smart contracts, blockchain, and in business, international business law. So I just missed my point in the very last final point here. But I guess what I've shared should be enough to at least instigate a debate where we can then discuss. I'm free and still available to discuss any questions that colleagues may have. But yeah, this is very much to say in a nutshell, in one sentence, an area that is still developing, and there is still some legal uncertainty to an extent in the Netherlands when it comes to arbitration of smart contracts. Ladies and gentlemen, I'd like to thank you for your attentive listening. Terima kasih. Thank you.
Thank you very much. Thank you very much, Dr. Prosper Simbarase Maguju, for valuable presentation. Ladies and gentlemen, we will now proceed to the discussion and Q&A. Yeah. Participant who wish to raise question may do so when invited. Kindly mention your name and institution before asking your question. Okay. Okay. 2 mahasiswa, 1 ya. 3 mahasiswa. Itu 2, 3. Mr. Muji. Yeah. Please running the mic.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Let me introduce myself. My name is Yulianti. I am the student of Master of Law of Sriwijaya University, and I also work at court from the High Court of Palembang. Okay, I am honored to be here because I can meet the incredible, gorgeous speakers. Thank you for coming. Thank you have come to Palembang. Offline and also online, all the speakers. And my questions are based from data from memory. There are only 12% arbiter understand about smart contract. I mean, Indonesia, from the Supreme Court, Mahkamah Agung Republik of Indonesia, has provided e-court. So all of the civil case in Indonesia, through not a manual court, but electronic court. but for the first time, before they come to the trial, for the first trial, the judge will ask about mediation. And then they can choose the mediation from the court itself or arbiter from outside. Maybe, but I think that not all of arbiter in Indonesia can understand about smart contract. So can you give us the solution for Indonesia? How to increase the knowledge for arbiter in Indonesia? So there are many the international arbiter in Indonesia. That's the first question. And the second question is data security. Indonesia has the problem about data security. Although Indonesia has data security regulation, but there are many cases about data protection in Indonesia. Because of phishing, that's become cybercrime in Indonesia. Can you give us the solution? Maybe start from your country, in Malaysia or Thailand or also Indonesia. Can give us the prevention from cybercrime itself? Because we know smart contracts is about a technology, but many scammers use the technology in a crime. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Ma'am, mau dijawab dulu atau di-collect dulu, Ma'am? Oke, dulu. Baik, second questioners.
Okay. My name is Salwa from University Muhammadiyah of Palembang. Well, I will give the question for for Dr. Liliana. Okay. Thank you for the opportunity. Well, glad to see you again. I was attend your seminar last year at 28th of May 2025. Okay, as what I saw from your presentation slide, I noticed something that got my attention. It's about Bank Negara Malaysia, shortly BNM, are not making digital assets our legal tender, right? So because of this, I was curious about this since its lack of legal tender status. Then user cannot rely on central bank guarantees, of course. In the Malaysian courts, in the event of a platform collapse, so does this status weaken the consumer positions in Malaysian courts when the consumer itself trying to claim the assets, okay, as a money or currency under existing financial legislations? Thank you.
Thank you very much. The last questioner from student.
Let me introduce myself first. My name is Anissa Aulia. Currently, I'm a law student in Faculty of Law at Universitas Sriwijaya, and I'm focusing on international law. I would love to ask a question to our guest and speaker. Recently, I've seen many cases on the internet where payment systems at Meria here talk about CRIS, and sometimes the payment initially experience errors or appear to fail, but later on proceeds the same transaction multiple times automatically, causing financial losses to the customers. In situations like this, where automated systems execute actions without direct human interventions, how should international dispute resolution mechanism determine liability and consumer protection, especially when the system operates through decentralized blockchain technology across different jurisdictions? Thank you.
Thank you very much for three questioners. Maybe we can start the answer from Meria.
All right, thank you so much for the question for Ibu Yuli ya. Ibu Yuli, actually just like I say that lack of arbitrators who understand about the smart contract and also the blockchains, of course it's not easy directly to make the people understand about that. Just like me, directly learning about the blockchain activity, about the escrow and then about the code, I think it's not very easy. But to be the arbitrators, of course, I suggest and then I propose suggestion just now that the institution may invite it or may recruit the expert of the IT. You know that whenever we would like to be an arbitrator, one of the requirement is the expert at least about 15 years expert in one field. So therefore, if we would like to recruit it, so the institution must find someone or the expert who understand about that and then train not about the code but train about how to be a good arbitrators. So they may combine, if it is panel 3%, means that the panel of 2 is from the senior and then the 1 is the expert. So but the senior must be trained, must be trained, join the training, join the seminars, therefore they will understand. But of course, if we would like to directly understand and then maybe studying about the programming, if it is not really our major, of course it's quite difficult. But for the smart contract, I guess it's not easy. It's not as easy as an LPC, but of course still possible to understand, especially if we are still becoming a young arbitrators, So I think it's still possible. Therefore, training, learning, and then comprehend, joining such seminar or studying, and then maybe brainstorming, and also just now for the institution recruit the one who understand about the IT. Okay, that is the first question from Miss Yuli, but just now you are asking Miss Ilyana. Anissa, excuse me, I couldn't get the point. Anissa, what about the settlement dispute about?
It was about the payment issues that we're currently seeing. There's a lot of payment issues that is failed to understand it. Maybe because it's especially when it comes to international payment, maybe at times when the payments needed, it sometimes appeared failed. But later on, they keep on decreasing the amount of money in the customer bank. So it seems like it failed, but it still the transaction succeed at the end. So it seems failed, but the customer still loses their money.
Okay, actually that is still under development, Some of the peoples, whenever they have a problem and then they pay some things and then we do not receive it, and then maybe just like what I did, I pay souvenir actually, and then I already use a QR code, but they do not accept it. So how we overcome the problem? Just wait until until our money is returned. So of course the country must create such a regulation, becoming some consumer protection about that. Also about the methods. The methods must be really improved, I guess. Therefore there is what we call keyakinan of the customer. The customer kepercayaan, the customer trust, Therefore, there will be the customer trust to join in such a platform, such as using platform or using e-bank or some payment from the website. But of course, the regulation I said just now, the regulation need to be improved. Always improve, because the technology, this one is the technology, and the next one may be different, so fast, grow so fast. That is my answer.
Please, Dr. Ilyana.
All right. So thank you so much, the moderator, and also the question from me is from Miss Salwa ya tadi. Yeah, Miss Salwa. Happy to see you again this year. Thank you so much for coming again from University Muhammadiyah Palembang. Yeah, all right. So she was asking pertaining to legal tender status. So yes, as I mentioned in my slides, okay, the Bank Negara Malaysia, the Central Bank of Malaysia, does not recognize Bitcoin cryptocurrency as a legal tender in terms of what can be constituted as payment for the Bank Negara Malaysia. Okay, but in 2021 and 2018, because in Malaysia we are based on common law, so not just regulation, we have case law cases. So in the case of Robert Ong Chen and Lee Eng Fong, 2018 and 2021, the High Court actually accepted Bitcoin, yeah, and Litecoin as a valid consideration. So that is a good development that actually our students, we have researched on this previously, have found these two cases only in Malaysia pertaining to crypto that the court accepted as consideration. But Bank Negara as legal tender means repayment, a mode of repayment yang di bank tak boleh. Yeah, tapi when it comes to Malaysia, the High Court of Malaysia, when Bitcoin and Litecoin was then be tendered as is this okay for the mode of payment for a personal contract between A and B, then the Malaysian court accepted it as a valid consideration, but as long as it can be something that is they say recognized as commodity or asset. So right now crypto is currently a currency and accepted. So in terms of consideration, one of the element of contract, yes, it is accepted. But again, for the Bank Negara Malaysia, it's not. It's not like a valid digital ringgit ke apa, belum lagi. Yeah. Tapi di Indonesia mungkin nanti boleh tanya yang di sini lah. Belum juga. Oh, sama. Yeah. Alright. Second question from Miss Alia tadi, ya dari Unsri. I think she asked all four of us pertaining to do we have any consumer protection for those that lost something pertaining to international transactions online, isn't it? Is that the question? Or any cybersecurity measures that the country have? So number one, it will come back to basic law of contract. So if it is a valid contract pertaining to law contracts at 1950 and e-commerce in Malaysia, then they can go to court and claim for any damages, any compensation based on that, number one. But number two, in terms of cybersecurity, any measures that we have, currently Malaysia we actually just enacted a law in 2024, Cyber Security Act 2024. So basically we have a committee in the national level that kind of will coordinate and see what can they do to lessen up the cases pertaining to cyber security issues and also fraud in digital world. Yeah, and we also have the Online Safety Act 2025 just last year. Okay. This is basically Malaysia is just introduced obligation or duty of care to the providers that they will have to be responsible for harm that caused by their platform. So that includes fraud that for all of us, and also for the minors, protection that the Malaysia give to the platform like Facebook or TikTok or TikTok Shop, yeah, Shopee or gimana. They have the responsibility to ensure that their platform are safe for the users to use. So that is new 2025. It was based on OSA or Online Safety Act 2023 of the UK. Yang tu baru ada, belum ada kasus lah, no case yet, but that is new. Maybe our colleague from Thai and also from Netherlands can also explain on their position.
Thank you very much, Dr. Ilyana. Next one, Dr. Saria Galasindu. Please give the answer.
Right, thank you for the questions. My answer to the first lady from the court, Regarding the arbitration, I do support Dr. Mary about the training, about the expertise of the arbitrators, but in a way, it's also happened in Thailand where the listed or registered arbitrators has no experience in arbitrating the case. So opportunity of the cases for the arbitrator is also important in order to develop and be trained to do the arbitration case. So the opportunity is where I acted in to improve the arbitration system in the country. And the second question about the cybercrime, it's also the significant issue in Thailand where we have a lot of damages and laws. In Thailand we have the specific police and law, but it's very sensitive, and I think we need not just the law but practice in national and the international level together, including in the ASEAN, especially for cooperation in terms of the different territory fraud as well. And for the last question, how's the ADR will help about consumer protection? This is quite hard really, because if we say about business, about trade, for example, World Trade Organization, then they will focus on the trade and businesses, where the consumer protection is another function, another panel, another group of nations, which means we individual countries need to develop and help our own consumer, although we have regional scheme to have the ODR in ASEAN, which is still ongoing and developing. But I think the ADR can be means, of course, for consumer dispute resolution scheme, but need the information and the knowledge to guide, to educate consumers, of course, first of all, and has to be always emphasized on that education part. And secondly is to develop the mechanism itself. In Thailand, mostly offline, which consumers seems to trust more than online scheme, because also the technical burden as well. So apart from educate them, develop the mechanism, and it's not only the national but regional and international level. So that would be my question. Thank you.
Thank you, Dr. Saria Galasinto, for your answer. The final answer is from Dr. Prosper Simbarasi Maguju. Please, Dr. Prosper.
Yeah, thank you. I was just listening to some of the questions, and I just have to say that in law, as in any other areas, there's really nothing new under the sun. So the courts can still resolve with the old methods that have been used in dispute resolution. Expert witnesses, I think the key in these kind of cases, because we are taking cases where technology is mitigating the law, and as much as we can do some training, capacity, it will be very difficult for every lawyer or the judge, mediator, and arbitrator to have full knowledge on how technology works. So this is where it takes witnesses who are coming from technology. So let's not try to become tech-savvy, to become invested in other degrees of technology, but let's also just good methods. Let's have technical experts to help us in arbitration, to spend homogeneity issues that are technology. That's my final contribution on the topic and the questions raised by the audience, and thank you for the questions, by the way.
Thank you, Dr. Prosper Simbarasi Magucu, for your answer. Ladies and gentlemen, today's discussion has shown us that blockchain technology and smart contract are reshaping international legal relations and dispute settlement mechanism. While these technologies offer efficiency and innovation, they also create serious legal challenges related to jurisdiction, enforceability, and legal certainty. At the same time, today's seminar reminds us that international arbitration remains one of the most adaptive mechanisms for resolving dispute in the digital era. Ultimately, the future of international dispute settlement will depend on how successfully law can evolve alongside technological transformation. I would like to express my sincere appreciation to all our distinguished speakers for their valuable insight and contribution. I also thank all participants for your attention and engagement throughout this seminar. Lastly, I sincerely apologize for any shortcoming during my moderation. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Ladies and gentlemen, we have now arrived at the closing of today's international seminar organized by the Faculty of Law, Sriwijaya University. We extend our deepest gratitude to all the speakers and the moderators for all the materials shared today. May the knowledge presented bring lasting meaning and benefit to all attendees, and may this event contribute to the development of international law, especially in this era of digital advancement.
We also extend our heartfelt thanks to the organizing committee for their contributions to making today's event into a success. That concludes today's program. As your masters of ceremony, we sincerely apologize for any mistakes in our words. We seek forgiveness from Allah Subhanahu wa Ta'ala.
Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Shalom, Om Shanti Shanti Om, Namo Buddhaya.
Greetings of goodness to all of us. Good afternoon and see you at the next opportunity.
Thank you, Mr. Prosper and Prof. Sari.
Have a good day. Bye.
Foto ramai-ramai sekali ya. Nanti Miss Iliana berdiri di sini, nanti dari depan boleh.
Mohon untuk partisipan untuk berdiri untuk berfoto bersama-sama. Untuk mahasiswa boleh untuk berdiri, kita foto bersama terlebih dahulu.